Welcome to another episode of Arbitration Life. I am Janette
And I'm Hana.
Hong Kong Arbitration Week 2022 takes place on October 24th to the 28th. Marking its 11th year, it will bring together the Hong Kong and international arbitration communities with a focus on inspiration, innovation, and interaction leading in modern dispute resolution. The BVI IAC is thrilled to be participating at this year's event with the session on the rise of offshore arbitration. It will be hosted by our good friends at Withers Worldwide on the 25th of October at 9 a.m. Hong Kong time. Hannah, you will be speaking at this event. Could you share with us some more about the panel?
Absolutely, Janette. So the panel, as you mentioned, is entitled The Rise of Offshore Arbitration, and it will be available online and in person. So it's a hybrid session. The session will examine the factors contributing to the rise of offshore arbitration, especially for disputes with an Asia-Pacific nexus, including the nature of cross-border investments and international commercial transactions. Discussions will include the intersectionality and nature of offshore disputes and the benefits of offshore arbitration. We have a terrific group of panelists, namely BVI Arbitration Committee member Charlene Tong, who works at Withers in Hong Kong, Tamika Davis from Conyers in the BVI, Edward Tellard from Sherman in Hong Kong, and our featured guest today.
Our guest today is a member of our panel of arbitrators who specializes in commercial and shareholder disputes with expertise in multi-jurisdictional disputes, obtaining interim measures in aid of arbitration and enforcement of awards in the BVI and Cayman Islands. He is able to advise clients in both English and Mandarin, and his clients include a large number of mainland Chinese companies.
While he is counsel in the litigation and insolvency team at Harneys Hong Kong office, he also has vast experience acting as counsel in both English and Chinese, as you mentioned, in commercial disputes under various arbitral institution rules, such as the HKIC, SIAC, ICC, and CTAC. He's also a fellow of the Charter Institute of Arbitrators. Please welcome Andrew Chen. Hi, Andrew. Welcome to Arbitration Live. How are you?
Thanks very much, Hannah, for welcoming me and having me on this talk show. I'm very privileged to just be with all of you today.
Certainly, it's a pleasure to meet you, Andrew.
Yeah, it's an absolute pleasure, especially to see the very nice coffee bar you have behind. I don't think I've seen any other arbitral center with such a beautiful setup.
Oh, thank you. It's very convenient for cocktails, actually.
Yes,
it is a very attractive amenity as well.
And morning tea or coffee.
Yeah, but we know it's evening for you because you're in Hong Kong. So how are things there? Are you ready for Hong Kong Arbitration Week?
Oh, yes, absolutely. I mean, you know that our firm has sponsored an event, and I'll also be speaking at the BVI Arbitration Center event next Tuesday. So much of this week and the previous week has been spent preparing for those two events, and also I do look forward to catching up with other arbitration practitioners in the community as well. As you are probably aware, Hong Kong has opened up, is abolished hotel quarantine, so hopefully we'll get to see more visitors from overseas during the next arbitration week. We're all pretty hopeful that will be much better than the past 2 years.
Yeah, absolutely. Yeah, we've heard that. It has finally opened up. We can't make it this year, but hopefully next year, that'll be great.
Yeah, and I definitely look forward to joining you guys at the BVI Arbitration Week, next year as well.
Yeah, absolutely. We look forward to that.
So Andrew, I'm going to go ahead and get things started. The first question I need to ask you is, what inspired your career in the legal sector, and how did you get started in arbitration?
Well, just thinking back, going down memory lane, I mean, after my A-levels, I had to make a choice of what to study at university. And at that time, for my A-levels, I remember that I got hired in the maths and sciences. And so probably becoming an engineer was the most natural progression for me to take. But I wasn't really that interested in sciences, nor was I really interested in the humanities such as literature, history, politics, or philosophy. So the law seems to be a sort of a best middle ground that I could really take. And both my parents were lawyers. My father taught contract and evidence at the local university. My mum was in charge of the legal department of a government entity. So I sort of settled for doing law as a major, as a default hand down from my parents, but not really knowing what I'll get myself into. And I mean, at the end of law school, in my penultimate year, I had to decide on what to do. And so I would say my foray into arbitration was really more of a chance encounter. And I remember it was the penultimate year of my university studies. We all had to think of places to apply for our training to become lawyers. I grew up in Singapore, and so my natural thought process settled on finding a good Singapore law firm. But I just didn't want to be just one of many trainees in a big law firm where you would just be probably overlooked. So I asked around to ask for whether there are good mentors. And people keep telling me that there's this guy, Michael Huang, who does very interesting cutting edge work, and he specializes in arbitration. Of course, at the time, I had no idea what arbitration was about. But I was just attracted to him by the phrase cutting edge work. And so I applied to him, and thankfully he took me in. And so I was very lucky to join his chambers. And then it was probably at that time that I found out that he was one of the best go-to arbitrators that Singapore had, as well as internationally within the APAC region. I didn't realize it at the time, but I think I was extremely fortunate to join his chambers. I did work for him as tribunal secretary, as well as his assistant solicitor assisting him in all his counsel cases, which were largely related to arbitration. So even as a very junior lawyer, I had the benefit of seeing things from the arbitrator's perspective. He would receive some of the better ICC cases, SIAC cases, even ad hoc arbitrations from prominent law firms in Korea, in Europe. And this is a time where I really cut my teeth in arbitration and learned what has forged me into the arbitration lawyer that I am today.
Oh, wow.
From a family of law to just getting right into arbitration pretty much.
Yeah, and to get a mentor like right from the beginning, and usually one of the most renowned arbitrators. So it's fascinating. Wow. Very interesting.
Yeah, I mean, at that time he just started his arbitration chambers.
Okay.
Because way back, the concept of a chambers dedicated to arbitration wasn't that well known, and he was, I think, one of the pioneers in that regard. And so I was just very lucky. And at that time, he just took in very few people, probably just 1 or 2 trainees a year. And because the prominent thinking at the time was that, oh, let's just go to a big law firm, become a trainee there, get myself under a big brand name, and work my career accordingly. So I took a slightly different path, and I think it has served me quite well.
Absolutely. So now, Andrew, so you mentioned Hong Kong Arbitration Week, and we're very excited about that. And the BVI is hosting an event there on the rise of offshore arbitration. So we will have the chance to discuss this a bit during our panel. But a sneak peek, what would you say are some of the factors parties should consider when choosing the seat of arbitration?
Yes, I think this is actually a very important question, because I realized that when you talk to your corporate colleagues who are actually inserting these arbitration clauses into their clients' contracts, they may not have this at the back of their mind. So although it's arbitration 101, but I think it bears repeating at every possible forum and opportunity you can get your hands on. So for me, I think there are 3 main factors. Number 1, is the jurisdiction supportive of arbitration? In fact, things you look at is that, do they have a judiciary and a supportive legal framework that seeks to uphold the arbitral process? Is the judiciary pro-enforcement, whenever a challenge to an arbitral award comes before the local courts. So one of the hallmarks of a good pro-arbitration jurisdiction is, does the seat adopt the UNCITRAL model law on international commercial arbitration into its arbitration legislation? And is the jurisdiction signatory to the New York Convention on the recognition and enforcement of arbitral awards? So that's point number one. Point number two, you can have the best arbitration infrastructure in the world, but do you actually have a good legal profession that can support that infrastructure? So I think having a strong and independent legal profession that can represent you and your interests when you need to go to court is just the other side of the same coin. And another point that people tend to ignore is, does it take a long time for matters to make their way through the courts? Does it take a long time for a judge to hear a challenge against an arbitral award? And would there be an appeal process that drags the process out ad infinitum? So these are some of the factors that support your consideration as to whether a particular jurisdiction is a good seat or not. And thirdly, and I think most importantly, is that when people come to your jurisdiction, do they feel that they'll get a fair, impartial, and neutral hearing? And I think that this is something that cannot be built. It has to be part of the DNA of that particular jurisdiction. And so, I mean, if I were to read between the lines of your question as to whether the BVI would be a good place to arbitrate, I think that the BVI would easily fit all these criteria. For example, BVI through the UK is a signatory to the New York Convention. It also adopts the UNCITRAL model law into the BVI Arbitration Act of 2013. If you look at the Act of 2013, you see that a lot of the provisions are a direct cut and paste from the UNCITRAL model law. And I mean, all of us are aware of the very strong commercial court which the BVI has in hearing all of these arbitration cases. And it's also very important to note that there is also a very strong legal profession supporting this entire framework. They're not just all the offshore law firms that a client could go to, but also many King's Counsel and English barristers are actually dual qualified in the BVI. So you have the benefit and the reputation of bringing English lawyers on board to your various cases. And this has sort of contributed to the perception that the BVI actually has a very strong legal profession supporting it. And last but not least, the BVI would definitely be considered a fair, independent, impartial, and neutral jurisdiction. Even though British Virgin Islands is a British overseas territory, the people who work there come from all over the world, right? I mean, yourselves and the people who set up companies there, how many of them actually come from BVI, right? And it is about as international a place that a place can be. And you can say that no one ethnic group or culture can be said to truly represent the BVI. You have people all over the world just coming to the place to do business. And I think that because of this very international element of the BVI, one can say that the BVI is really a truly neutral and impartial place above all else.
Thank you for that, Andrew. We're definitely very diverse here in BVI, that's for sure. You know, as a great follow-up question, I believe, as counsel who represents clients both in litigation and arbitration, what are your clients' main reason for choosing arbitration over litigation?
Well, I can say that having been in large international law firms where I have had to advise corporate colleagues on the arbitration clauses, I think the simple answer is that actually most clients choose arbitration simply because the lawyers put it into their contracts. And that is mostly for the less sophisticated clients. But if you're talking about the more sophisticated clients who actually have in-house counsel that look closely at the contracts that have been drafted for them, I would say that the primary factor is because of the element of confidentiality inherent in arbitration versus the very public nature of court hearings. Let's take, for example, if you were a major property developer and you wanted to sue a contractor for defective work, you definitely don't want anyone to know that you're undergoing this dispute, right? Otherwise, how are you going to sell your properties for high price? And also, and I think that this is also possibly the reason why, if you were to engage a law firm, you see that increasingly law firms have stuck arbitration clauses in their contracts because they simply don't want to have to wash their dirty linen in public. So I think that, I mean, all things being equal, confidentiality is actually the most important element, which sort of attracts a client to take up arbitration instead of court litigation. Another factor, I mean, is just industry practice. Say, for example, the construction industry, they use fixed form contracts, they use a lot of industry forms. They just take in arbitration clauses. The shipping industry as well. For most of their bills of lading, as a historical practice, they just take in arbitration clause, regardless of whether it's well drafted or not. So history is actually another factor that goes into the equation of whether a client chooses arbitration.
Thank you so much. And just to follow up quickly on the confidentiality, actually in the BVI Arbitration Act, and I'm sure you know that, Andrew, like all court-related proceedings are also confidential. So yeah, I think we're very big on confidentiality here, which is definitely an asset and why people choose arbitration. So now, Andrew, what would you say you enjoy most about your role as counsel?
I think two things immediately come to mind. So if I could just rephrase your question, what are the two most enjoyable things about being counsel? I think the first thing is really learning new things that have nothing to do with the law. So let me just give you an example. One of the earliest arbitration cases I did concerned defects in the luxury residential estate in Hong Kong. So did you know that for every floor, usually you have a lift lobby and then a number of flats around one lift lobby. And if the temperature differential between and the level of humidity between the lift lobby and inside the flat was too great, your doors would have this very warped appearance. I bet I didn't know that before I did one of my first cases in arbitration. And so this was a very interesting fact. And did you know that if you look around your bathroom, you wouldn't realize that there's actually an invisible layer of around 1.5 meters from the floor up to the wall, so that when water splashes on the wall, it doesn't get into tile and seep into the next room. And I wouldn't have realized that if I weren't doing a construction arbitration case. And one of the things I realized is that Hong Kong has a very strong environmental policy in favor of protecting trees. And this arose out of one of the early construction cases I worked on. So this, as a condition of a government leasing land to a developer to build, one of the conditions was that they had to protect each and every tree on site. And each and every tree was actually labeled with a number. And there'll be inspectors to check on the health of the trees. So if during the construction process, any tree was damaged or any tree had died, then there'll be a very hefty fine on the property developer.
Oh,
and this is not something that you know about just reading the news. And I'm very glad that these little interesting tidbits of information that you learn about when you do arbitration, and possibly because of the fact it's confidential as well. So less people would know about all these interesting facts and figures that come from doing arbitration. And I think the second most interesting thing is really learning empathy and how to engage with the client. And I'm sure you are aware that all clients are worried about the cases in which they're responsible for, whether they show it or not. And they sort of rely on the lawyers to hold their hands like little children and guide them through the process. So you not only have to understand the legal position, but you also have to digest it and break it down into a message in which they understand. And unfortunately, I feel that this is a very critical part of a lawyer's skill set that's just not taught in law school. And so it was during this time that you try to put yourself in another person's shoes to see what they're thinking, and then try to cater your message accordingly so that that person understands. Especially delivering bad news. If a client has lost an arbitration, I think one of the greatest challenges to a lawyer's skills of advocacy is how do you tell the client bad news. And I don't think that this is a skill set that you can learn in any other profession except being counsel.
Wow, so true. Great answer.
Interesting. So Andrew, what difficulties have you experienced in your career and how did you overcome them?
Right. Thinking back, I think obviously there are many ups and downs in one's career, but two of them come immediate. So that was the first difficulty. The second difficulty that immediately comes to mind is something that's encountered by most arbitration practitioners. How do you get your first arbitral appointment? And I must say that it took a long time for me. Whenever you attend seminars on how to get your first arbitral appointments, everyone says that you must network, you must get yourself involved in the community. And so I did all that, all right? I did all that for a number of years, but nothing came about. Then one fine day, I started getting preliminary inquiries from the HKIC, even though I wasn't on their list of arbitrators yet. So I felt that my efforts were paying off. But after 3 or 4 preliminary inquiries, they never materialized into an arbitral appointment. I learned subsequently that the HKIC would ask 3 candidates, and most of the time it's only a first rank candidate that gets appointed. And so I was for a period of time I was like appointed and impressed. Then one fine day I got an email from HKIC to say the appointments committee has approved your nomination for this particular case. Now can you clear conflicts? So that came totally out of the blue, because usually you ask an arbitrator to clear conflicts before you pass the name on to the appointments committee. But in this case, it was slightly reversed. They probably felt sorry that I got rejected so many times. So I cleared conflicts, and thankfully I secured that arbitral appointment, and I went on to issue my first arbitral award. Yeah, so I would say that my arbitrator career is still in infancy, but it's something that I hope to grow over the years. And I do take solace in the fact that the average age of arbitrators in the ICC is 50 plus. So I'm still considered relatively young in that regard.
Okay. Wow. Well, thank you for sharing this. Very interesting stories.
Yeah,
and
it
for
is.
the second story, I think you were on the radar of HKIC for a long time, which is great. But it's true that it takes time. So thank you for sharing that. So Andrew, now, what is the most memorable case you have been a part of and why?
Let's see. I think the most memorable case that comes to mind was actually an ICC case involving a dispute between a distributor and manufacturer of high-end medical devices in mainland China. There were a number of cases, there were a number of takeaways that I would say makes this case quite memorable. Number one is that, as I mentioned earlier, in arbitration, you get to learn a lot about non-legal stuff, right? So this case concerned radiotherapy devices. And radiotherapy devices, they are things that try to kill your cancer cells without the use of surgery. So they have a particular device shining either X-rays or gamma rays onto you. And so they hope that this is a much cheaper and less invasive way of curing cancer. And so not just learning about the nature of how radiotherapy devices work, but also learning about the medical system in China and how such devices are allocated in a socialist regime. I mean, in a capitalist capitalist society, it's up to every hospital to decide what it wants to buy, right? I mean, it's like the BVI AC deciding should I buy this computer. And it's just a decision that's made internally. But when it comes to a socialist economy, it's actually the state that decides who gets to buy a radiotherapy device and how many devices they get to buy. So you see the considerations that actually go behind the scenes as to how expensive equipment is allocated throughout China. And I think one of the more heartwarming facts of this case is that the client was very engaged in the entire process. They treated me and my team to a number of meals and encouraged us. So it's this really warm interpersonal relationship with the client that makes this case quite memorable. And last but not least, the reason why it's memorable is because it was my first experience in being given the opportunity to cross-examine a witness. At that time, I was a senior associate, and obviously, because it was a big case, on top of me were two partners, but they were kind enough to give me the opportunity to cross-examine one of the witnesses. So I remember I cherished it, and I spent a total of 4 to 5 days just memorizing the material and coming up with questions and thinking of various ways in which the witness could evade me and how I could bring him back to say what I wanted him to say. And I mean, I didn't manage to break the witness, but I know from the award that I managed to convince the arbitrator that this witness was not someone who was considered to be credible. So the arbitrator didn't give any weight to his testimony. And the encouraging thing about that experience is that the North American partner who flew in to do the case together with my supervising partner complimented me, as well as the other colleagues who were with me on that same case. Even after a few years after the event, they just said, "Oh, Andrew, I think you're a very good lawyer, and remember that cross-examination you did for that case." So that was a time when I felt really encouraged, and when I felt that I may have a talent for advocacy as well.
Wow,
And
congratulations. Of course, it's memorable. The first cross-examination and
Yeah.
you won. That's great.
Yeah. So Andrew, what is the best piece of advice you have ever received?
I would say that, again, there's no one best piece of advice. If I had to think about it, I think there would be 2 pieces of advice. Number one is that the advice given to me when I was very junior is that the ability to communicate and write clearly is more important than technical knowledge. Mr. Michael Huang, not just being a very eminent arbitrator, was also a member of the plain English speaking movement for the legal profession. So it's not an organization that you hear or read about, but apparently it was formed by this university lecturers to promote plain English and legal correspondence. So what he would do is that he will correct my drafts. He was very old-fashioned. He would take a red pen and correct all my drafts, and most of the time he had effectively rewritten it. And I was just surprised that someone who was so senior, above the age of 60, he can just communicate his messages in a very punchy and succinct way. That no matter how hard I tried at the time, I couldn't. But obviously, I've improved a lot since then. And so when I became senior enough to have my own trainees that I had to supervise, I would always share this advice with them, because I realized that I would implicitly judge a trainee's work by how well they communicated in terms of the level of writing which they exhibited in their emails and advices, as well as how they form in oral communication. So I mean, technical brilliance is of course important, please don't get me wrong, but to achieve that, you just have to sit down like a hermit, spend a few weeks reading up on the latest case law, and you can easily become technically brilliant as the most brilliant lawyer out there. But writing and communicating clearly takes a lifetime of practice. And the second lesson I learned was something that was more recent, is that you should not try to be everything to everyone. I realized as I became more senior that you need to persuade clients to just give you work, right? And a lot of people just pretend to be able to do everything. You'll just be amazed at the number of lawyers out there who say, I can do A, B, C, D, E, whatever you want me to do, I can do. But the reality of life is that you can never be a specialist in everything. I think most clients realize that and can see through the charade. They rather that you just focus on your specialties, on who you are, and just advocate your strengths and work on those strengths so that they can see the kind of value that you bring. So this has been a very delicate balance that I've been trying to perform in the past few years of my life as I try to get into a role where I have to bring in clients to build up my practice. Yeah, the balance between trying to persuade a client to like you and just trying to be yourself. I think those would be the two most important pieces of advice I'll give to everyone who wants to be a lawyer.
Very good advice, yeah.
Thank you, Andrew. Now, reflecting on your career in law, what would be 3 words to describe your journey?
3 words that would describe my journey. Let me see. I think the first word would be enlightening. I've referred to the fact that you learn a lot about non-legal stuff in the course of being an arbitration practitioner. Of course, I do other things apart from arbitration. So unless you're talking about plain vanilla debt collection case on a winding up application, let me just talk about some things I've learned about this world outside of arbitration. So I participated in dawn raids on companies led by the ICAC and SFC, the Securities and Futures Commission, as well as the Independent Commission Against Corruption in Hong Kong. So I got to see how they conducted their investigations, what kind of information, and how they conducted the searches. So these searches they come in the morning with search warrant and they last until the next morning, 4 a.m., 5 a.m. And you sort of get a feel as to how these kind of things go about. But otherwise, you just read in the news, there's been a dawn raid on this company, that company, but you never get to see behind the scenes actually what goes on. And I've also had the chance to advise a client on how to dispose of an aircraft stuck at the Hong Kong International Airport because the aircraft company refused to pay the parking fees. This is something that's extremely remote to the practice of arbitration. So I had to get my hands dirty in figuring out aircraft law from scratch. And it was very interesting that the client taught me a bit about the airline industry and how airports work and what are the commercial ways in which you can use to persuade the Hong Kong International Airport to give you your stuff. And I also come to face to face with extremely wealthy people who have admitted that they've committed fraud or whom you just strongly suspect are bad guys. These are people that you see in movies, that you read about in the news. You never thought that you actually come face to face with them, but I guess in the course of one's practice, nothing is ever surprising. So I've come face to face with them. They are very professional on the surface. They are very polite, but and you can't tell from just looking at them that they are crooks, but some of them are. Yeah, so these are things that I have, I would say, enlightened my legal career. Another buzzword I would say is community. And to succeed in life, not just in law, but everything else, you need support and advice of people around you. And I think this applies generically for every career. Everyone goes through a tough time every now and again in their lives, and you just need to sit down with someone, whether it's your peer or junior, and talk through what you go through, not just yourself, but them as well. They also need someone to come to whom they feel comfortable with and talk through their difficulties. So this kind of open sharing encourages you when you face similar difficulties as well. And it builds bonds of friendship that goes beyond just having a professional working relationship with your colleague. And you tend to see a person more. You tend to see the nuances when you're close up with them, tend to judge them from their position in the law firm, the number of mentions they get in legal directories. And this is, I think this is really the most important part of one's legal practice. As to how I'll describe it, community. This word community. A third word I would say is challenging. I think if you are the lawyer today, as opposed to a lawyer in the 80s or 90s, where you can just be siloed in one practice area, I think anyone you ask to describe their legal career, one of the words they use will be challenging, because you constantly just have to retool yourself. The market is extremely saturated with lawyers who are just as good, if not better than you. So you constantly have to upgrade and diversify your skill set, learn about crypto and things that you wouldn't necessarily touch, but for the fact that you need to expand your practice. So to me, I think the job of being a salesman is always the hardest part of being a lawyer, the most challenging part for me, because I am an introvert by nature. So throughout the course of my legal career, I stepped up outside my comfort zone and networked and spoken to people whom I've never met before and whom I don't seem to have any common interests before sitting down for a meal. So that has been, I think, a very challenging part of my career, but also a very rewarding part as well, because each time you overcome a challenge, just feel, hey, I think I'm getting better at this, I'm getting good at this, I think I should just press on.
You certainly
So
are.
yeah, I mean the three buzzwords, enlightening,
Yeah.
community, and challenging.
Beautiful. Thank you so much, Andrew.
Yes. So Andrew, I love all your three words, especially your last word, challenging. And on that note comes our bonus question, which could be challenging, but I hope it's not too challenging. And
I'm ready for anything.
You're ready.
Fire away, fire away.
So our bonus question is simply, what is your theme song? You're getting ready for an arbitration. What's that song that you would play in the morning? What's on your iPhone? If you're an iPhone user, I assume. That gets you going.
Right. I think it's this very catchy tune that I recall. Believe it or not. It's a theme song from the 60s. It goes something like this: believe it or not, I'm walking on air.
Yes.
I never felt so free. I first heard it when I was watching a Michael Moore documentary about George W. Bush becoming president of the United States. So no one at that time thought that he'll be president of the United States. So Michael Moore, I think, in jibe and parody against George W. Bush, he played the song "Believe It or Not, I'm Walking on Air." It's like this guy that got catapulted right to the top. And so because I so like the tune, I looked up iTunes, I downloaded it, and I'll listen to it from time to time.
Nice.
And I mean, going to arbitration week, or I mean, not just arbitration week, but any particular work day, you know, I just feel very blessed that that I am still alive, I'm still in this profession, and I'm still moving ahead. Yeah, I mean, if you asked me 10 years ago, would I still foresee myself being a legal profession? I would say I don't really know, because a lot of people drop out, as you probably expect. Every year you get people just leaving the profession. And I think this one of the major gripes about a legal profession today is that it's just too draining on oneself. And yeah, I mean, it's just something to behold that I'm still in this profession at this time in my life.
All
Thank you
right.
so much, Andrew. Thank
I
you.
love it. Believe it or not, I'm working on here.
Okay, I'm going to listen to it. Thank you so much, Andrew. And thank you
Mm.
also for mentioning the doubts, because it's true, it's something that's we see all the time in our profession. We'll be here, we're working hard, and we're very happy that we were able to talk to you today and to learn more also about you.
Yeah.
Yeah, exactly. And thanks very much for having me online. I mean, it's been such a great pleasure speaking with the both of you.
Likewise,
Thank you so much, Andrew, for joining this episode of Arbitration Life.
and for more arbitration lives, please be sure to hit the subscribe button and to follow us on LinkedIn and Twitter at Arbitration Life.